My lord, memo. Matter is likely to be settled outside the court, my lord. It may be referred to the mediation. So,
Where is the matter?
my lord,
Where is it?
memo, my lord. Here, submitting.
Moving a memo today.
Please, my lord.
Yes.
Tomorrow or day after tomorrow, it may be taken.
Yes.
Serial number 26, my lords. The petitioner father is not present today, my lords. He is unwell and under medication, my lords. He is requesting for 1 week time. He has to travel from Bangalore. It is posted for
medication.
Ill health, fever, and he said he is having some fever. My senior informed me to make submissions. My lords. 1 week. I have informed.
Not fair on his part.
I have informed the other side.
What I'll do is I'll pass the order on in this petition. Without
1 week's time, sir. 1 week's time is prayed.
What 1 week's time? When the matter is posted, you say that he is not aware. He left to the village, left to his place.
The next day, the very next day, it was called, my lords, for that purpose. Week's time, I have informed.
It appears that his intentions are not correct.
No, my lords. 1 week's time. Next week he will be present. I have informed the other side as well, my lords, that he is not present because the wife is from Bangalore only. He has to come from Bangalore. That is only the difficulty, my lords. 1 week's time is prayed.
If there is a court order, you have to come.
Please, that is I bowed on, ma'am, for that.
This is matter next week.
Most good.
My lords.
Call the list.
My lords, moving memo, my lords. My lords, the interim prayer in this needs to be heard, my lords. We're pressing on the visitation rights for the non-custodial parent, my lords.
Which year is that?
24, my lords, 2024, my lords.
What happened to the order passed by the family court?
My lords, this petition mainly is like challenging the maintenance, my lords, but we've asked for the visitation rights as well in this, my lords.
In this petition?
Yeah, in the
in an RPSC?
Interim prayer, my lords.
RPSC?
WP, my lords.
WP maintenance IA for visitation.
My lords, it's
no.
My lords.
No. Yes, next.
Let's moving now, my lords. WP GMFC, my lords. Enhancement of maintenance.
Which year is that?
22.
Listed on
And has not paid it maintenance,
on July 15th. Call the list.
Your Honor, GMFC, this is a custodial case, Your Honor. It was supposed to be listed after vacation. Your Honor, the dealing of the case is affecting the child's mental health. Kindly post it tomorrow or day after.
Yes. Which year is that?
Your Honor.
Which year is that?
2024, Your Honor.
Yes. No, what you do is, no, please come to the order. Paragraph 12. 1 minute. Oh, so what is this in this? MBC. 1 minute. This is MBC number 3011 and 3012. In the next matter. No, this writ petition in this itself, it refers to both the cases. So, come to the first paragraph. First paragraph. So, award passed in, it should be MBC number 30. So 3012, no appeal is preferred. So that has to be here. Hmm. Para 12, where the, what has been awarded by the tribunal is wrongly. Yes, it should be 3011. That's yes. Uh, para? Uh, where is that? Where is that? Paragraph 10. The claimant had sustained the pain, swelling, and deformity of the right ankle. No, no. Paragraph 10, it's not there. Read it. There is no paragraph 15. No, no, you just tell here. What is it? Uh, hmm. So what are the injuries that has to be incorporated here? Hmm. Yes, please come. Uh, in this first matter, MFA 7708, paragraph number 1, MFA number 3012 of 2008, that has to be deleted. Then coming to paragraph number 10, take the file and with regard to this MVC number 3011, whatever are the injuries that are stated, that has to be, this has to be is typed here. And then coming to the table at para 12, whatever or the compensation that is awarded by the tribunal as per 3011, all that has to be typed this way. Yes.
Case number 2, Vijay Kumar for appellant,
Yes.
P. Pradeep,
1 minute. Paragraph? Page 4. No, no, first it starts with MFA number 7745. It should be 46. Hmm. Hmm. Then? Yes. Huh. 8. Hmm. 45. Hmm. As it is, I've written it down. Yes.
case number 3, dismissal, case number 3,
And for the petitioner, my lord, in the second petition, that is 3.1, he has not complied. The husband has not complied the order, conditional order of this honorable court. That is why it was.
Order sheet in the next one. On 23/2024, this court has passed an order that the husband, by the next date of hearing, should clear all the, should deposit all the pending arrears and no further time will be granted. On that, interim order granted earlier is extended till the next date of hearing. When the matter came up on 23/6/2025, Then counsel appearing for the wife is present and there is no representation on behalf of the then counsel appearing for the husband. Then the writ petition that is filed by the husband is directed to be listed for dismissal today. Today also, there is no representation on behalf of the then counsel for the petitioner or the husband. Accordingly, WP number 27630 of 2023 is dismissed for non-prosecution. Post this delete post WP number 5811 of 2024 on 9th of July.
Cell number 4, Naveen JN. Cell number 4, Naveen JN for petitioner.
My lord, is the pleading is stricken off by the lower court.
What is that?
Pleadings has been stricken off by the lower court based on the petitioner itself is filed a section 9 application initially, and that is disposed of because he is not
You are for the wife or
wife. My
husband has filed the restitution petition.
petition file.
Serial number 4, Lordship.
Within that time only, he has filed the application for the cruelty for the divorce.
Hmm.
That is also pending, and this is also pending, and
Restitution MFA is also pending.
that is also pending.
Then he filed this petition.
Yes, ma'am.
Sitting
To avoid,
there.
just to avoid the maintenance,
Ah.
and the maintenance cost is only 5,000 rupees per month. Ma'am.
Granted, in which case restitution.
2022, he has to pay from 2022.
Then
Still, he has not paid.
hmm.
He's a MTech and structural engineer.
No, what is the order impugned now?
Hello,
What is the order impugned now?
my lord, this WP filed because the application filed by the wife for the to strike off the pleadings.
That was allowed.
That is allowed, my lord.
Uh,
And the citation is quoted by this honorable court itself in that Komala versus Ravi Kumar.
hmm.
Now, before this, the husband is before this honorable court.
Where is that order? The agreed with the order passed in I number 7 in MC number 13 of 2023 dated 25th September 2024. The husband is before this court. This matter came up on came up on 23/6/2025 as there is no representation on behalf of the petitioner husband and as counsel for the respondent is present. The matter was directed to be listed today under the caption for dismissal.
Naveen JN. Naveen JN. Naveen JN, sir.
Watching the proceedings.
Just logging in and keeping quiet. What is that?
Naveen JN. Sir, you on your video, sir?
Is there? Yes, get in.
Lordship, I appear for the petitioner in serial number
Yes,
4.
Mr.
Sir, your case is going on, sir, please. Naveen JN. Sir, can you hear the court all proceedings, sir, please? Naveen JN, sir.
Call those technicians. All them. Yes, Mr. Mr. Naveen.
So not able to hear the court proceedings, Your Lordship.
ಮ್ಯೂಟ್ ಇಲ್ಲ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Now are you able to hear?
Sir, can you hear the court all proceedings, sir? Please, Naveen JN, sir. Please.
Madam, are you able to hear the court?
I'm able to hear the court, Your Lordship. Mr. Naveen
Supplicant-
does not seem to be able to hear it.
Call and tell him that the matter will be taken up immediately. Let him reconnect again. Yes, next matter. We'll take up. Yes.
Sir, Naveen JN, sir, your matter is passed over. Please you reconnect properly, sir. Cell number 4, 5.
Appearing for the petition in this matter, Millard.
Cell number 5.
Office has raised the objection. Why made a party to respondent number 2 in the operative portion of the CMIS 105, Millard. Because no relief sought against respondent number 2 minor daughter.
Then why did you make the, that is not, whatever is the cause title, you should do it again. Office objections was sustained. Shall be complied with in a week.
In the course
Report
of the day,
order.
I will comply the office objection, Millard. I'll kindly taken up on tomorrow or day after tomorrow.
If the office objections are complied with, immediately list the matter.
Cell number 6. Consider Narayan Ekde.
Interim maintenance order is under challenge. The impugned order is, the impugned
Regarding maintainability.
regarding maintainability.
Oh.
The order is passed under section 125 of CRPC. That is an interim maintenance.
Then,
In view of the bar under section 19(4), my lord, the office have raised an office objection regarding maintainability. I may be permitted to convert it as a writ petition, my lord. In fact, I have made a search
So why
also.
should
Some
you-
of the courts, my
No.
lord.
why should you come here? You could have done it by this time.
No, I will do it. I will do it as, I will convert it. In fact, I
Uh,
made some search also, ma'am, for
I
reference.
saw that judgment, that will not apply here.
Please.
The office has raised an objection with regard to the maintainability. In your section 19 for the family court, there's an order, it's an order granting interim maintenance. Office objections are sustained and the petitioner is at liberty to convert this RPFC into a writ petition
Please, oblige.
within 1 week from today.
Please, in some of the courts, my lord, in fact, had held that, my lord, the interim.
I saw the judgment of the
Please,
Allahabad
please.
High Court.
Correct. Himachal Pradesh, please. Allahabad High
But
Court
they
as
said
well
that
as,
it is an
as well as
issue of
Himachal Pradesh High Court.
And they're all arising under 482.
Correct. There was the petition filed under section 482,
They
but
said it
however
is a
in the.
revision lies.
Exact.
Revision lies.
Revision lies.
I'll tell you what happens is
Please.
in Andhra and Telangana,
Please.
125 CRPC proceedings,
Please.
against that only a criminal revision is filed. Here in Karnataka,
Please.
any of the matters of family court,
Please.
again, it's an interlocutory order and a petition is filed.
Please.
So it is nothing but a
Please,
revision
please.
under
I agree, my
227.
lord.
Yes.
Please.
So that judgment also supports what the office is saying.
Please.
Yes.
Cell number 7. Narendra A.
Yes.
Lordship, I appear for the petitioner, Your Lordship. Lordship, this petition is filed challenging the petition,
Complaints of office objections,
the process fees paid, Your Lordship.
non-furnishing of PF. No,
That's
there are
all.
other objections also. Non-taking of hand summons.
That has not been accepted by the counsel for the respondent.
Then you should file a memo to that effect,
I'll-
saying that we have taken out hand summons and it is not accepted.
I'll file a memo.
Office objections to be complied with in a week. Yes.
Lordship, if a short date can be given, there's an urgency.
Sir, once office objections are complied with, list the matter.
Please.
Yes.
Number 8. Party in person, Lina Abraham.
Waiting for the respondent, Your Lordship.
Yes. No representation by the party in person. This is matter on 15th of July.
Much obliged.
Uh-huh. You can't help it, no? Let them make whatever ruckus. 15 July.
15. Still number 9.
And for the petitioner in this case, my lord, there 125 maintenance petition,
In serial number.
enhanced
9.
petition, it is for petitioner.
Lords, in serial number 9.1, I filed my NOC Wakalat, my lord, on 17 June 2025.
You filed.
Yes, my lord. My name may be shown.
Where is that memo?
I filed.
You're filing the NOC Wakalat.
Yes, please.
When did you file?
17 June 25, my lord.
Are you ready?
My lords, I may take some time to file my
The
objection.
condonation of delay,
At the request of
300
for the
days, it may be,
respondents
may
in
kindly
RPSC
condone the
number.
delay, my lord.
How can it be 298 of 2024? Does this matter after a week?
Still number 10.
Mr. Sridhar Prabhu's name may be deleted and my name.
Delete the name of Mr.
Sridhar Prabhu.
Sridhar Prabhu. Then you should file Wakalat here also.
In first matter in 298, I filed.
You filed in
Yes.
RPFC 309 also you have to file.
Yes.
We will not ask you to delete. Once you file Wakalat, it will be
I
deleted.
filed already, my lord. It is filed on 17th. 17 June.
It is submitted that 9 in RPFC 309 of 2023. Mr. Take that council's name. So and so has filed Wakalat. If the Wakalat is filed, print the name of so and so and delete the name of so and so Sridhar Prabhu.
Still number
Yes.
10.
Hateful.
Ketan N. 10.
My lord.
I appear for the respondent and I filed an application for vacating the stay order.
Let's see where is the
of
improved order.
maintenance.
My lord. I have filed this petition.
Come to the improved order straight away.
Page number 22, my lord. Page number 22. Impugned order. It is an interim order. Passed on IA number 2. Filed under section 125 class 2 of CRPC by the family court. Directing the respondent husband to pay 10,000 maintenance from the date of filing of the instant IA and one-time litigation expenses of rupees 10,000 to the daughter.
What is your income?
My income is 8,000. 8,000. I am working in a Ayurvedic shop.
Let's look at, come to the order.
No opportunity has given me to file objection and also hearing
What do
opportunity.
you mean by opportunity?
My lord, kindly go through the order sheet, my lord.
Yes.
I produced the order sheet.
Page number?
Page number. Page number 49.
When did you receive the notice?
During the SOP COVID period, I have received the notice. Kindly go to the page number 45, dated
No,
27.
when did you receive the notice? You can give the date also to the court.
No. On 27/5/2021, it is mentioned as on page number 45, served personally as per the office note. Page number 45. During that, it is a COVID period, SOP was there. I am unable to engage the counsel at that time. Thereafter, I appeared on 22/11, page number 49. Advocate C. SGV files Wakalat for respondent along with IA number 413 of the family courts. I had pursued allowed. Respondent is permitted to engage the counsel. Objection to IA number 2 and affidavit of access and liability are not filed by the respondent. Advocate for the petitioner submitted arguments posted for orders. Directly they are posted for orders. No opportunity has been afforded for me.
So from 21, they will wait till 23 for you to do all
so
this.
COVID period was going on.
Not
SOP,
COVID period, 23 was not COVID period.
SOP was going on.
No, 23, no SOP.
SOP was there, my lord.
Till what time the SOP was there?
On 8/7/2021, as
I'm
per
talking
SOP
about
of Honorable High Court.
Till 2023.
No.
Where is from 20 COVID till
2023, not 2020. On 2020,
You filed
2022.
Wakalat in 2022.
22.
What are you doing from 2022 to 5/9/2022?
SOP was going on, my lord. Kindly
You
go
will
through
not
the-
file.
But he is unable to engage the counsel. He is going through
a lot of things, my lord.
All
That's
these
why.
stories will not hear.
Thereafter, but
What is the purpose of this interim application for maintenance? You can engage an advocate, but you cannot file your
my
statement
lord,
of assets and liabilities for 9
but my
months.
lord,
And you blame the court that court has not given
no,
opportunity.
no, I'm not blaming the court, my lord.
Now the court has already given directions to all the family courts. Maximum is 1 month for disposing of these applications. Whether you file, you don't file, that's who doesn't file, that's their problem.
But my problem is, my lord, she is working at the time of order. She was working. That was not disclosed before the trial court.
You are there to disclose.
No, my lord. That's why no
You
opportunity.
didn't do it, is the question.
If opportunity has provided me, I would have filed my objection and
No,
such
this
time
what
left.
has been done in the year 2023. Now we will again take it.
When I
we'll put
filed the
clock back.
wakalat, a single opportunity has been granted me. I would have given all the documents. No opportunity was given me. She was working. She has properties. Everything she has.
Not from 22/11/2022. You wait till when is the order passed?
On 8/12. 8/12.
8/12.
22/11.
22/11.
Order was passed on 22/11.
Yes, my lord. SOP was there, my lord. Running. SOP was running.
And I'm not able to understand what is this SOP.
Standard operas.
So what is the standard?
High Court has directed
what
if
the High Court said, you file your wakalat, but you don't file your statement of assets and liabilities.
He was unable. No, he's unable to engage the counsel.
Able to
During
file-
that period, he was going through a lot of sufferings, my lord. In a COVID period, he was not earning. Everything was like that.
Take it that.
That is the reason.
You just want to drag on the proceedings, nothing else. And you want to take advantage of
No, I'm
the
not
COVID.
taking it. She was working, my lord, but they are not disclosed before in the assets and liability. They have misled the court. They are taken the order.
Have you filed your statement of assets and liabilities? Is it your case that you're not working?
No, she is working at present, but during the time when the case was filed,
Huh?
she lost her job.
When did she lost her job?
I have produced all the documents in respect of that. And she was asked to resign during the pandemic. For more than 2 years, she was not having any job.
What was the interim order?
And he has not paid.
What was the interim order?
Interim order was directed to pay the 10,000 for the daughter and one-time litigation expenses.
That's not the interim order of this court I'm asking.
This court has stated the interim order, directed me to pay the 50% of the amount. I have complied it. They have taken it.
Then we will remand this matter and let both of you file your statement of assets and liabilities afresh.
My lordship, presently what has happened is, give me that. Because the child has finished her schooling, she has started going to the college. The mother is spending more than ₹1 lakh for fees, and he is giving all false. I placed all my gold and started a business, medical shop. He is having a partnership business. I produced the GST number of the partnership firm. He is earning well. Now recently,
Will direct the court.
He has not paid
Will
anything.
direct the court to dispose it off in 1 month.
My lordship, I want the order to be vacated because I need money. The stay order is passed for stay of the.
I'm going to set
amount.
aside this order, not the stay.
Maintenance amount has been stayed. I need money.
We'll
My
set
problem
aside.
is my
My
child
lord,
is going to college and
She is
as a
falsely
father-
submitting. She has filed another case. She is 40 before the magistrate court, wherein court has directed, passed the interim order to give the education expenses for the daughter. That I have appealed before the Sessions Court. That order has been stayed, but Honorable Sessions Court directed me to pay the education expenses. I paid 2,25,000. That they are not disclosing before this
What is
court.
that expenses?
Education expenses
That you are paying.
that I have paid. They have received that amount also. They are not disclosing before this court.
Agreed with the orders.
Completely misleading the court.
Number 2 and criminal miscellaneous number
My
77 of 20.
lordship, may I just give me some permission? Because the
So
child
please understand, the court has passed an order as he has not filed his statement of assets and liabilities. Now he says, my income is only 8,000. Question of paying 10,000 will not arise, isn't it? So for you to get a better order, let this matter be remanded to the court and the court decided within 1 month. That's in your interest. You might be getting more also with all this, material you're going to place. Agreed with the orders
So
passed.
matter may be referred to the.
Yes, I number 2 in criminal
But
miscellaneous.
for the time being, whatever order is passed, he
That
should
will
pay the
continue.
balance amount.
That will continue.
When there was an arrest warrant was issued in execution petition, then only he has paid half of the amount. When the stay order was filed, my lordship may go to.
You're not continuing to pay.
No, madam, the order was passed.
Orders.
Order was passed.
How can such an order be
I
there?
paid, they have taken the 1,80,000. The matter is set for the cross examination of PWM. They are not appearing before the court. Last days also they are not appeared before the court.
Your income is 8,000.
Yes, yes, madam.
Court has asked you to pay half of it. There should be a continuous order.
No, no, no. 1,80,000 I paid. I complied.
The order now I'll pass is that half amount, what you have paid. From that time till today.
No, filing of
whatever
the
is,
petition. Filing of the
whatever
petition.
it is,
paid.
that half amount
I have paid.
till the IA is disposed of,
Disposed.
you need to pay. Agreed with orders.
This amount and then.
IA number 2 in criminal miscellaneous number 77 of 2021 dated 8 December 2022. The husband is before this court. By order impugned, the court had granted an amount of rupees 10,000 from the date of filing from the date of filing the petition, and also granted one-time litigation expenses of 10,000. When counsel appearing for the petitioner submits that during the COVID time, he had received the notice and without even giving him an opportunity, the court hastily has passed this order. Had an opportunity is given to the petitioner, he would have put forth before the court that the wife is having sufficient means to maintain herself and his income is only 8,000. And as the opportunity is not given, it is submitted that the order may be set aside and the matter may be remanded to the family court. Next one, when counsel appearing for the respondent wife had filed the vacate petition, and it is stated that the girl has completed her school and joined the college, and it is becoming very difficult for the mother to take care of the educational and other necessities of the girl. Further, it is submitted that he is having businesses and also the GST number and other details were already placed on record, and the order that is passed by the court is a reasoned order and no interference is called for. Next. Having got the counsels on either side for the material.
The balance amount of the arrears may be paid. Balance amount of arrears you should pay. Because I am finding it.
That is what I said, madam. That's what I said. The other counsels on either side. There is a material on record. The only grievance of the husband appears to be that no opportunity is given to him to file his statement of assets and liabilities. This court has seen the proceeding sheet. After the appearance and the next date of hearing, the court had heard the IA and posted it for orders. The petitioner, having appeared before the court through an advocate, should have filed the statement of assets and liabilities. This court in majority of the cases is coming across where without exhausting the remedy that is available to them, that is for filing the statement of assets and liabilities, and having no other go, the court will pass the order. Then the parties are coming before this court and seeking to remand the matter on that ground. It is nothing but wasting the judicial time. In the incident case, to pass any orders on the merits of it, both the parties are coming up with two different versions, and the entire material, that is the statement of assets and liabilities of the husband, is not on record as such. This court is not in a position to decide the matter on the merits of it. Further, as an interim order, the petitioner is asked to pay 50% of the arrears, and as a one-time amount, he paid an amount of rupees 1,80,000, and thereafter he has not paid the amount. This court deems it appropriate that the husband shall be directed to pay whatever is the 50% amount, that is at 4,000 from the date of petition till the petition is, till this IA is disposed of by the family court. In that view of the matter, this court is passing the following order. Order dated so and so, so and so, in so and so is set aside, and the matter is remanded to the family court for fresh consideration on the IA for interim maintenance. Number 2, the statement of the parties without further notice shall appear before the court on 3rd of July, and within 1 week from 3rd of July, that is by 10th July, the petitioner and as well as a respondent shall file their respective statement of assets and liabilities, and the court shall dispose of the IA by 12th of August.
Subsequently, I have filed, my lord. After that, I have
What if you find it's fine? By 12th of August. Next, no further time, the court shall not grant adjournments, and no further time will be granted for disposing of the IA. Number 2, the arrears calculated at 4,000 from the date of petition till today, deducting the 1,80,000 that is already paid, the petitioner shall pay the remaining amount till today by 16th of July. Next, and from today by, what is today's date? 20. By from today by 24th of July, he shall pay the amount, and whatever is until August 12th is the date. No, he has to pay the amount, and whatever and the remaining is subject to the further orders to be passed by the court.
time limit may be set to dispose the main petition, my lord.
No main petition. First let this go.
Then,
Yes.
then number 11. BM Halaswamy BM for petitioner.
Monday again. No? Yes.
Can you see, my lord? So order passed by the family court, my lord, in respect of interim maintenance, my lord. It's not disputed, my lord. Both the parents are working, my lord. The respondent, my lord.
Let me understand. There are two petitions. You appear for whom?
I am appearing for the wife, my lord. The wife and
First
the children.
petition is wife's petition.
Wife's petition, my lord.
Second petition is?
Husband's petition.
So, what is the maintenance granted by the court?
Maintenance 10,000 each to the minors, my lord. It's not for the wife, my lord. It's only for the children, my lord.
Now, wife is before this court seeking maintenance for her.
Enhancement for the children, my lord.
How much you sought?
30,000 has been sought by the school fee itself come to more than 1,50,000. School fee for each of the children, my lord.
No. You sought how much?
30,000 each, my lord.
30,000 each. What is the husband's salary?
Husband salary, as per the court's, my lord, affidavit of what it says, 1,09,000, my lord, page 40. Paragraph 13 of the impugned order, my lord. Page, paragraph 13 of page 40.
What are you doing?
She's also an engineer, my lord.
What is her salary?
Her salary is 1,02,000 as per the affidavit of assets.
1 lakh?
2,000.
1 lakh 2,000. 1 lakh, his salary is 1,09,000.
1,09,000.
So children's educational expenses are?
Pardon?
Yearly expenses are?
Yearly expenses, my lord, I will pass on this memo, my lord, wherein it's 1,50,000 per educational expenses, my lord, other expenses, excluding transportation fee, my lord. 1,50,000 for each of them, my lord. They are studying in Chaitanya Techno School.
Per annum?
Per annum, my lord. Apart from that, my lord, there are other expenditures which he has not paid even from the date of desertion. He files a petition for a dissolution of marriage, my lord. His petition is the earlier petition. my lord.
You said 1 lakh? Expenses, 1 lakh
Expenses 1,50,000, my lord,
to each.
to each of them, my lord.
So that is 3 lakhs per annum.
3 lakhs per annum.
Hmm. So both of you are earning. You have to pay, you have to take 50% of it.
Yes, even if it is the not only educational expenses, my lord.
No, if
Yes.
you take it,
Yes,
it should be 1,50,000 for, only it is 1,50,000 to the husband towards educational expenses.
1,50,000 that's educational plus transportation fee, other expenses at 20,000, my lord. That's what. Even if it's sharing, my lord, what it comes to, my lord, it's very meager. What the 10,000 which has been awarded, my lord, the other expenses.
What is it coming to 10,000? That is 10,000, 1,20,000 per annum. 1,20,000 comes to 2,40,000. Is what do you say?
But so far as educational expenses are concerned, they were not school going, at that time. I don't know, for the first time they are making submission here.
Let's see. Let's.
Because 5 years,
No, let's look at the order. Please come to the.
educational expenses.
Not only that, medical expenses
claimed,
also she has.
Then why are you calculating what is not claimed?
The maintenance is granted to each of the children at 10,000 per month, which I have challenged, it should be shared among both. So far as school is concerned, I don't think, they have placed any material before the court below to show that they are school going.
Yes, what he says is right.
Yes, my lord. Though there no material has been.
No, without asking in a revision in RPFC, why should the court will look into?
No, even will
Scope
not.
of RPFC is very limited.
Yes, my lord. Even without looking into that, my lord, we'll assume, my lord, there are 2 children, my lord. What would be the expenditure of the children, my lord? And even we'll assume when the children are the age are.
No, you're asking 60,000.
Not 60,000. Let the court enhance, my lord. It's not only what they have claimed 60,000, my lord. Now both of them are having salary more than 1 lakh, my lord. Whether the petitioner being a father, my lord, even if he is not looking after the children,
So
my
what
lord.
is the father's contribution to the children? Father's contribution to the children, you're earning 1 lakh per month.
1,09,000.
Yes.
She is earning 1,02,000, but she has not produced, salary certificate. Her income is more than that. Apart from that, she has a multi-storied building in Shumaga city, earning 40,000 per month as rent. That she has not disclosed. No salary certificate is produced. On the other hand, I have contended that I have produced the salary certificate. Her income is much more than that. Now what is ordered is 10,000 per child. No other thing, my lord, has been brought on record regarding school and all that. My submission is that 10,000 plus 10,000, 20,000 will have to be shared by both. Because she is earning.
So according to you, you will contribute 10,000 to each.
Yes, 10,000.
You will earn 1 lakh and you will contribute only 10,000.
10,000 out of 20,000, my lord, per month.
And where is your appeal is?
Yes, the petition is there.
Yes.
But as far as the expenses is concerned, I don't know, how we can bring all those things which is
No,
not
that
there.
you could, if you're not understanding that I can understand.
Yes.
But you saying that I will 20,000, 10,000 how the wife will bear and 10,000 a wife will bear, that is something which the court is not able to understand. You will contribute for 2 children 10,000 and wife will take care of them. Wife will take care of the entire expenses.
No. Why I am saying is, court below says 10,000 is the requirement for children, for each of the children. Then in that event, my lord, that would be the expenses, my lord, for the children that is going to be incurred. Therefore, what I am saying.
No, if you rent a premises that she is paying, who will pay for the rent? Rent will come, you will get it in 10,000.
No. She is, my lord, she has let out, my lord, that house from a multi-story building. My lord, apart from 1,02,000 and odd, which he says his salary, which is salary certificate is not produced, which is more than that. But he is earning, my lord, she is earning, my lord, 40,000 per way.
She didn't ask for her maintenance.
Not maintenance.
She's asking for the children's
she is
maintenance.
capable of, my lord, contributing.
She is capable. You are also capable.
Oh, no, my lord, what has happened is my mother, my lord, fell sick. She was suffering from cancer. My lord, I am also having, my lord, backache and spinal issue, problem. I have produced documents, my lord. I have incurred loss of, my lord, huge loan, my lord, and I had to repay it. 25 lakhs, my lord, for my mother I sent. I spent and I've been paying. My lord, now
I will leave it open for you to raise all your grounds with regard to the educational expenses of the child. Will increase 5,000 for both the children, 15, 15, 30.
At least, my lord, 20,000, my lord, kindly say. When the children are there, it is,
It
my
is
lord.
without even your expenses, without even the educational expenses. Now once a court is granting educational expenses, let the court look into this. It is open for the court to revisit it. That's what I'll leave it to the court.
But interim order, by way of interim order, my lord, 15,000 I've been asked to pay. Lord, which I have paid, my lord, up to date.
Agreed with the orders passed in.
Lord, that may be modified, my lord, to that extent.
Agreed with the orders passed in. The orders passed in I number 1 in criminal miscellaneous number 154 of 2022 dated, what is the date of order?
Date of order is
24/7/2023. Both the father and mother are before this court. The mother's petition is WP number 29037 of 2024 and the father's petition is WP number 2804 of 2024. The court the mother has asked for maintenance of an amount of rupees 30,000 each to the children and the court had granted 10,000 each. The mother and father both are aggrieved by the said order. Mother seeks the enhancement and the father seeks reduction of the said amount. Land counsel appearing for the father submits that both of them are working. Father is earning an amount of rupees 1,09,000. Mother is only earning 1,02,000.
more than.
That I'll record in your contention. 1,02,000. And the father has not taken care of they were staying separately from
2003, my lord. Sorry, 2000.
I think 20 is the
2022, my lord.
right from
2020,
2022. They're staying
20,
separately.
2020, my lord.
20, my lord, I think.
2020 they are staying separately and the father has not taken care of the children. Now they are the school going children and no educational expenses are paid by the father. It is submitted that for both the children they are spending an amount of rupees 3 lakh and odd towards the school expenses. It is submitted that the amount of 10,000 that is granted by the court is on the lower side. Then counsel appearing for the respondent submits that the wife had not disclosed the correct facts with regard to her finances. According to the counsel, she is having more, the salary which is stated before the court is much more than what has been stated, and she is also having a multi-storied building which she has let out, and she is earning.
She has not produced the salary certificate, my lord. That should be, it should be produced, my lord.
She is earning much more. Both of you not file your statement of assets and liabilities.
No, I have filed, my lord. I have produced the salary certificate. She has not filed.
So and so the
She has not produced.
what did you write? So and it is submitted that the amount of 20,000 that is granted by the court, that is 10,000 each to the children, is on the higher side. And in fact, considering the financial capacity of the wife, the 20,000 should be shared by both of them. The next para. Where the counsels on either side there is a written on record. There is no dispute about the fact that the wife is, both of them are earning almost equal amounts, and the wife is completely taking care of the children. The court had granted 10,000 each. The submission of the counsel for the petitioner for the father that the wife is earning more and he will only pay 10,000. Such submission is not acceptable. The wife has not sought for maintenance for herself. It is a responsibility of the husband to take care of the responsibility of the father to take care of the children. Admittedly, his income is 1,09,000, and the wife is taking care of the responsibility of the children completely. In the considered opinion of this court, looking at the financial capacity of both the parties, the husband has to pay 15,000 each to the children. Then coming to the educational expenses, no such application is filed before the court below. It is open for the parties to, it is open for the mother. Liberty is always open to the mother to seek for the maintenance of the children. And while determining the educational expenses, the court can also reconsider this amount that is granted by this court. Next, accordingly, RPFC is disposed. The RPFC filed by the mother is allowed, and the RPFC is partly allowed, and the RPFC filed by the father is disposed. 15.
Maybe that your lordship, but as on that day, that was not so much of any. It was order is given effect from 22 million. Now from today, Milord, your lordship can make it. 10,000, let it be reconsidered, Milord, on giving the expenses and all that. I will also.
No, they let them come up with a fresh application for.
Yes, Milord, till then, Milord, this 10,000 at least will be returned. But small children, Milord, that much they will not incur, Milord. Small children. Milord, it is.
Why the father has filed an appeal? Why the father has filed an appeal saying that 10,000 wife should pay and he will pay 10,000? You earn 1 lakh and you say that I will not even pay 10,000 to the children.
No, I am not saying that, Milord.
But then where is a question of appeal?
I am saying that it should be shared by both.
Why should it be? Already she is taking the responsibility. You have no, you're not doing anything for them.
Expenses, Milord, expenses, Milord, your lordship.
All the more reason for filing this appeal. This has to be
Let it
enhanced.
be confirmed. Let it be confirmed, Milord. Let in the fresh application to be filed. Let it be considered, Milord. Till now, Milord.
That same 10,000, and the court shall determine. So while determining that, this can be ordered. Yes. Both petitions are disposed of. Yes, next. Oh, so and so. Yes. Next. That in the next. No, I have not remanded it. I have not remanded it. Where is the question of saying salary certificate? Yes.
Channel number 12. Ye Balakrishna.
10.
Ye Balakrishna Shastri.
Make your application.
No, I will make an application, not 50.
No, 20,000 for children who are staying at home.
Not staying at home, my lord. They're already fifth standard, my lord. Being father, whether he doesn't know.
For that, where is the material that they are going to
even,
school?
my lord,
You didn't ask for it.
My lord.
That's why I'm leaving it open to you from the day they are going to the school. Whatever the expenses that you can collect, and for them staying at home, you will not incur more than 20,000 for 2 children.
My lord, it's not only, my lord. Kindly say, they are not staying at home, my lord. They are already fifth standard, my lord. Father, whether the father doesn't know, my lord.
You want the court to visualize it. You have to say it.
We have to say, my lord. But
where are the pleadings, Mr. Counsel? You can't say something without there being pleadings.
But my lord, it's a minimum amount, my lord, where she bears the, my lord, or rent, my lord, whether she is taking care of the children, my lord.
That's why now the matter is left, and even this amount, what is granted by the court. I said that the court can revisit basing on the material on record. Yes, next.
Channel number 12. Ye Balakrishna Shastri. For petitioner.
What is this?
My lord, husband's petition, my lord. Wife had filed an IA seeking direction for the petitioner to pay an amount of rupees 15 lakh towards educational expense of the son and 30 lakhs towards the educational expense of the daughter.
What is the order?
Order is IA was allowed, and
the petition is directed to pay the actual educational expense of both children from the academic year till completion of their education, apart from 15,000 per month. What is the salary of the husband?
My lord, actual figures I am not.
Without the talking, how do you expect the court to pass an order?
Yes, my lord, I'll make a submission regarding that. But also, wife is a software engineer who's also working and earning. Son was staying with the husband.
Come with actual figures day after tomorrow.
Yes, ma'am.
Channel number 13. Doctor Sudarshan L for
No
petitioner.
representation, list after 10 days.
Cell number 14. Ramu B.
Lord petitioner, writ of mandamus, my lordship. Writ of mandamus to early dispose of the case, my lordship.
Which year is the MC?
2021, my lordship. Husband has filed 2021, my lordship.
Which court is this?
First additional family court, Bangalore.
What is that? You had the statement last time? Third issue. It is not possible. 17 matters are also pending. Same, the petition
There's
is
no
filed seeking
representations
so-and-so
of the
relief.
respondent, my lordship. No representation from the respondent from the family court also. The stage has been
So-and-so,
closed.
The petition is filed seeking early disposal of the MC pending for 2021. The land counsel for the petitioner submits that you are for the wife or husband?
Husband, my lordship.
Submits that the wife is not representing before the court and the matter is pending from 2021. This court cannot pass any order directing the court to dispose of the matters pending of the year 2021 when there are older matters. But however, it is directed that the family court shall proceed with the matter in accordance with law. And if there is no representation on behalf of either of the parties without a plausible reason, the court shall not grant unnecessary adjournments. Yes, next. So notice to the so-and-so is not usual. No notice is given to the respondent as no adverse orders are passed. That will be there, no, in every order. Yes, next.
Number 15.
Lord, I'm appearing for petitioner wife, Lord. I'm challenging the order dated 5/12/2024 passed by the Honorable Family Judge that down there. Only on the ground of application not maintainable, assets and liability affidavit not filed in the open court.
That's it. For what?
Lord.
Why you are not filed such a statement of assets and liability?
Lord, my application filed on 17/1/2023, Lord. Dismissed order passed in on 5/12/2024. After lapse of 2 years.
If you don't file the statement of assets and liabilities, even after 2 years, what do you expect the court to do?
No opportunity given.
What opportunity? What opportunity? It mandates that you have to file. You didn't file. Why court has to give you 10 adjournments, file your statement of assets and liabilities when you're not diligent? In fact, this is a specific order from the court. Yes. And I don't find any reasons to interfere. Let your when you are not diligent, let the court pass order and there is no informative that. Where is the order?
Not
page number.
Page number 12, sorry, page number
12 is your
page
petition.
number 45, Lord. Manager F. Address. Page number.
Page number
53.
Petitioner is who? You are absent. Respondent present. Both counsels are present. Respondent counsel submitted is still pending. The said application filed on, but respondent has not filed affidavit of assets and liabilities and not complied with so and so. And IA is not maintainable. Same is a petitioner directed to keep present petition without fail. Call on. Yes.
Please.
No.
Kindly permit the.
We will not. We cannot keep the High Court keep on telling the courts to dispose of the matters, and they do the matters in accordance with law. When it comes to the High Court, if High Court starts interfering, and what is the message the High Court is sending to the family courts? Why they will pass orders if the court, for every order without any basis, if the High Court starts interfering? Please come. The present petition is filed. Agreed with the orders passed by the family court in MC number 334 of 2022, whereby the court had dismissed I number 3 filed under section 24 of the Family Court Act, the MCs of the year 2022, and the IA is filed in the year 2023.
17/1/2023.
17/1/2023. And even till the impugned order is passed, impugned order is dated
5/12/2024.
5/12/2024. The wife had not chosen to file the statement of assets and liabilities as per the judgment of the Honorable Apex Court in Rajneesh versus Neha. Court, considering the said fact, has held that said application is not maintainable and dismissed the IA. Assailing the same, the husband is before this court. Learned counsel appearing for the wife is before this court. Learned counsel appearing for the wife submits that court has not given him a reasonable opportunity and had dismissed the application in this manner, and it would cause lot of hardship and prejudice to the wife. Next paragraph. Having heard the counsel peruse the material on record, the order impugned is passed with the court after waiting for nearly more than a year from the wife to file the statement of assets and liabilities. The submission that no opportunity is given, this court is not able to appreciate. It's the responsibility of the wife to file her statement of assets and liabilities if she wants maintenance, interim maintenance, as per the law laid down in so and so. When even after lapse of more than a year, when the wife had failed to file the same, the family court had no other alternative but to dismiss the petition, and this court finds no infirmity with the said order passed with the family court, accordingly dismissed.
Till number 16, Abhinay Vaiti for petitioner.
Yes.
Respondent seeking for nullity of marriage in the year 2022, Your Worship. Respondent number 3, IA number 3 seeking for maintenance. The family court grants interim order 10,000 for maintenance and litigation expenses for 25,000. Admittedly, the petitioner was in a final year. LLB is having LLB course is working as an intern in the advocate office. They have not earning any capacity. Admittedly,
what were you doing before that?
Yes.
What were you doing before that?
Before that, we are.
What is your age?
Age, Your Worship. 34.
So you must be doing something. You started doing law now, but you were doing something. What were you doing?
Started 3 years course for the LLB course.
Before that?
For the 2 years work.
You must be doing something. You
Yes,
must
Your
have filed your statement of assets and liabilities.
Yes, Your Worship.
What is where? Please come to the order and come to the discussion.
Advocate for respond file an objection stating the application page number 87, Your Worship. Page number 87. In page 4.
Come to the reasoning part.
Your Worship.
Reasoning part.
Reasoning part. Point one, in case there is no dispute regarding the fact of marriage of the petitioner and the respondent was solemnized on 13/3/2028 Radha Krishna Convention number 8 situated NAT Road, Gandhinagar, Basavangudi, Bangalore, in accordance with the Hindu religious and Shastric rites. It is also not in the dispute that after marriage, the petitioner joined the company of the respondent in the matrimonial home. They resided together nearly for a period of 3 months. It is the specific case of the petitioner that the respondent from day one avoided the petition and there was no consummation of marriage. It is a specific case that when the respondent was asked why he was avoiding at the time of he himself as told that she is not interested, but also she is not completed to having sexual life. On the contrary, it is specific case of the respondent that after the marriage was consummated and without any reason, the petitioner left the matrimonial home. Her intention is only to grab the amount of her property of the respondent and his family. He was subjected to cruelty in the hands of the petitioner during her stay in the matrimonial home. Whether marriage is consummated or not, whether the respondent was subjected to cruelty in the hands of the petitioner can only be ascertained after trial. From the proceeding of this case, it is clear that trial is already commenced. The affidavit by way of chief examination of PW1 is already filed. Now the question is whether at this stage the petitioner is entitled for the interim maintenance from the respondent is to be seen. In the case of both the petitioner as well as the respondent, have submitted their affidavits of the assets and liabilities. Even though in the application of the petitioner has claimed that she is no source of income, but in the affidavit, assets of liabilities.
No, you're getting salary of 15,000 from the advocate.
Advocate
Why
internship.
he's giving it as a cash?
Yes.
He's giving you cash.
Yes, you are, by way of cash.
You spend 30,000 to your mother every month.
He is looking after his parents and
No, you
himself.
said you are spending 30,000.
He's
You
a final
spend
year course.
30,000, you should get some income.
He's finally course. He's also in working as school in yoga teacher.
So that she's earning.
She's
But you know, nothing, no connection between your one statement and the other. Pay was, it is submitted that he studied 3 years law course and working in the office of an advocate, and his income is 15,000 per month. The court, without considering the same, had granted 10,000 maintenance to the wife, and the wife is having sufficient means to maintain herself. Considering the submission of the land counsel for the petitioner, they shall bestow for further proceedings. Same 5,000. Arrears also at 5,000 within 8 weeks.
Till number 17.
Yes. Notice to the respondent.
Wife's petition, my lord. The order impugned was keeping the IA number 2 in abeyance, which is filed for interim maintenance by the wife and posting the matter for evidence. The trial court matter was there yesterday, and even though it is notified before the honorable trial court that the WP is under consideration, the honorable trial court has dismissed my petition for non-prosecution, my lord. Nothing remains for consideration. I just want my submission to be noted, because this will be ground for me to file my RPFC.
No, anyhow, even if you file a writ petition, how is it a ground for the trial court not to pass any orders unless and until there is a stay from this court?
There is no stay, but
no, that kind of consideration, the family court was right in not considering your submission, because now it has become, you file a writ petition, keep quiet and tell the family court that my writ petition is pending. Of is it bound by it?
It is filed in the month of March, and there was a court vacation in the May, and I have moved it very urgently.
But you know that these are all not the problems of the family court. Where is the impugned order?
Impugned order is in page number. It is dated 29/1/2025, my lord.
29/1/2025
in the order sheet.
The petitioner wife is before this court questioning the order dated 29/1/2025, a docket order dated 29/1/2025, wherein the IA that's filed under section 125 CRPC was, the court has observed that as the wife has failed to address arguments on IA number 2, the application for maintenance will be considered on merits, and was directed to file the affidavit of assets and liabilities as directed by the Honorable Apex Court in Rashesh versus Neha. When the matter came up, land counsel appearing for the petitioner submits that after filing this writ petition, the main IA itself is dismissed by the court. Is it?
Petition itself.
Main IA number 2.
Not
Or
IA number, petition
125
itself.
petition itself is dismissed.
Petition itself for-
125 petition itself is dismissed by the court. Hence, nothing survives of a consideration in this petition. Accordingly, dismissed.
Cell number 18.
My lord, and for the petitioner, my lord, the sought for writ of mandamus, my lord, dispose of the pending MC number 326, 2024, 23.
Which year?
23, my lord, 2023.
Court.
The family court, my lord, principal family court, Shivamogga, my lord. Principal family court, Shivamogga. The matter.
Comes within my this thing only, no? It comes, no? I think they can. The present petition is filed, seeking the following relief. considering the submission of the Land Council. And as MCs of the year 2023, this court deems it appropriate to pass the following order. So and so is directed to dispose of within a period of 6 months. In a period of 6 months from the date of receipt of the copy of the order, and next, no notice to respondent, as disposal in the interest of both the parties. Next.
Chair number 19, disposed. Samir Hassan.
Yes.
Disposal.
Lord, the award of maintenance is only to the first petitioner, and the award of maintenance is denied to the second petitioner. So he is physically and mentally challenged. Only 3,000 is awarded. We have sought 10,000
Come to the
each.
impugned order. Page number. Operative portion first. Petition number 1 is who?
Petitioner number 1 is the wife of the respondent. Petition number 2 is the
So
son.
petition number 1 is the wife.
Wife. Petition number 2 is the son.
Why it is dismissed, sons?
Since no, she had not produced the document showing that the boy was physically and mentally challenged.
Physically?
Physically and mentally challenged. That document was not produced in the trial court. That is the reason why the petition came to dismiss against him, as against him.
No, even if he is otherwise all right, also father has to pay maintenance.
Father has to pay maintenance.
What is the financial capacity of the father?
No, financial capacity, he has a shop, stationery shop he is having. Apart from that, he has large tracts of land in Uttarahalli, wherein my lord, his only job is.
Is he paying 3,000?
No, he is not paying. He is ready to go to jail, but he is not paying.
So, if he is ready to go to jail, send him jail.
Yeah, we have sent him several times.
He went also.
Yeah, he went and he will come.
Then what is the purpose of
Four times we have sent him.
So what is the purpose of this petition now?
No, we want to attach his properties because he has properties, and I think.
So that you have to do it before the trial.
Yeah,
court.
that we can do, my lord. But here we have, this is for enhancement of maintenance.
How it is? What happened to the notice to him? How did you take out notice?
Notice, it has gone. Served on.
How it is held sufficient?
It was held sufficient on the previous hearing date. It has gone to his address and he has not received it. Intimation is delivered to him.
Returned unclaimed. Yes, let's see.
Yes.
What is the amount claimed?
My amount claimed is 10,000 each for the two petitioners, mother and son.
Now come to the discussion part.
Yes, ma'am. At page 12, my lord.
Para 17.
Page 12, para 17, my lord. As these 2 points are interlinked with each other, they are taken up together for consideration to avoid repetition of appreciation of evidence on record. Petition number 1 is the wife and petition number 2 is the son of the respondent, wherein they have claimed maintenance of rupees 10,000 each towards their food, shelter, clothing and medical expenses. Marriage between the petitioner number 1 and respondent is solemn as 24/4/1997 as per Hindu Rights and Customs Act. Premachandra Kalyana Mandapa near Ashoka Pillar, Bangalore, in the presence of relatives and friends of both families. Same is not disputed by the respondent. It is his contention due to the harassment by the petitioner number 1. He has filed petition for divorce in MC 3261 of 2013. In the said petition, petitioner number 1 filed application claiming maintenance, wherein it is awarded sum of rupees 3,000 to each petitioner. The said order is questioned in WP 41618 of 2017. It is the contention of the respondent that for one or the other reason, petitioner number 1 is harassing and would even the properties were allotted under bequeath through will by her father. It has been sold and same had been invested towards the construction of building. From the said building, petitioners are getting rental income of more than 50,000 after availing of benefits. The respondent was thrown out of the matrimonial house by filing cases against him. There is no any relationship between petitioner number 1 and the respondent to discharge their marital duties. She had also filed partition suit in respect of the self-acquired property of respondent's father, and the suit is partly allowed. Respondent is not having any residential accommodation. Now it is difficult for him to lead his life, but the petitioner number 1 is getting monthly income of rupees 50,000 by way of rent for non-payment of the maintenance amount to the petitioners. The respondent has been sent to prison. She had suppressed about her income. Petition number 2 is earning member who is aged 22 years. So the respondent contends petitions are not entered for in maintenance. Petitioner number 1 got herself examined as PW and in her affidavit filed for examination in chief. She had reiterated.
Oh, under what is the under in where in other cases what is the maintenance she's getting?
In 2 cases, she is getting 3,000 each.
So there's 6,000 already.
In the original suit that she filed in the year 2002, she
6,000 there she's getting.
2,000 to her and 1,000 to the son.
3,000 she's getting there.
Yes.
And
then we have filed for enhancement.
MC?
MC, it has stopped, my lord, because it was only an interim maintenance that we had sought.
How much there?
There, MC 3,000.
6,000.
Yes.
Then in somewhere it says 2 lakh was awarded towards
2
compensation.
lakh, yeah, that was not given at all. That she was not able to
9,000
recover.
was awarded on health grounds in criminal appeal.
Yeah, that was in the DV Act. 2 lakh was awarded, but we are not able to recover that. That was not paid as maintenance, but as a compensation under the provisions of the DV Act. And he is living with another woman also. And he has clearly admitted that in one more civil suit that
There is an order of maintenance of 6,000, not 3,000.
no 6,000 to both, my lord.
That's what.
To both.
Not 3,000. That is in the MC. In the suit that is 3,000. That is 9,000.
Yes.
And what the business, what he's doing is he's selling agarbatti.
Pardon?
He's selling agarbatti according to you.
No. Stationery. He has the
25,
stationery.
page number 25, internal page 18.
25.
From how long they are separated?
My lord, since a very long time they are separated.
What happened to the MC?
The MC, it was dismissed.
MC filed by?
He had filed the petition for divorce and that was dismissed. And there was an order for restriction of conjugal rights.
She should have settled it.
No, they are not ready for any settlement. That's the problem. The first thing is he doesn't come to court. Even the OS filed for maintenance, my lord, he had never appeared. Those notice was served on him. Only in the execution petition he will come. When the arrest warrant goes to him, he will come. All the while he will be enjoying his life. And he is living with one lady called Padmavati. Only thing is he has money to spend for the other woman, but not the legally wedded wife and the son, who is physically and mentally handicapped. Lord, if he was incapable, if he was unable to feed for himself or to any other person, my lord, I would have understood, my lord. He has been living with another woman for a continuous long time, and he himself admits in a OS filed for partition by her daughter and this son.
What is his problem?
Pardon?
What is his problem?
He mentally and physically, from birth he is like that. What the lady says is, while she was pregnant, he had hit her on the stomach, and that's the reason he was born like this. And that's what, my lord.
Please come. With the orders passed in criminal miscellaneous number 312 of 2016. dated 17th October 2023. The wife is before this court seeking enhancement of the maintenance. The application is filed seeking maintenance of an amount of rupees 10,000 to the wife and 10,000 to the son. It is the case of the wife that the son is a right from the birth is physically and mentally handicapped. The husband has deserted her and living with another woman, and he is capable of maintaining the wife, and in spite of the same, he is not taking care of the legally wedded wife and the son, who is mentally handicapped. By way of the order impugned, the court had granted maintenance of 3,000 per month to the wife, and as far as the second petitioner, the son is concerned, the court had refused to grant the maintenance, that no document is filed to show that he is having ailment. Next one. While granting the maintenance, the court observes that the court grants 3,000, observing that the additional amount that is already granted to the wife, that is 2,000 she is receiving, and accordingly granted the maintenance of 3,000. The next parallel counsel appearing for the petitioner submits that the petitioner, what is her age now?
Pardon me?
What is her age now?
Age of the petition number 2, my lord. One. 62.
The petitioner is age 62 years, and the boy who is
29. Boy is 29.
Boy is 29 years, who is suffering with the mental illness as well the physical ailments. She is not in a position to take care of them. The amount of 3,000 that's granted by the court, she is not in a position to take care of all the needs. Land counsel submits that the court went wrong in giving an observation that no certificate is filed. He submits that though he is 29 years old, he looks, even to look at, he looks like a small boy. It is also submitted that both the mother and the child are present before the court. And even looking at the boy itself, the court can come to the court can understand the mental status of the boy. It is submitted that the court ought to have granted the maintenance as sought for. Next para. Though the notice to the respondent returned as unclaimed, and this court by order dated so and so has held that the notice to the respondent is sufficient. Next para. Having heard the legal counsel for the petitioner peruse the material on record. The material on record shows that the husband had sold certain properties, had entered into certain transactions. Even before the trial court also, he has not subjected himself to cross-examination. And this contention that in spite of an order of the court, he is not paying the amounts, nor coming before the court. Even in this case also, the notice is returned as unclaimed. It shows how the husband is avoiding to come before the court and shying away from the responsibility of taking care of the wife and the child, who is mentally and physically incapable of maintaining himself. Considering all these aspects, this court is passing the following order. The husband shall pay an amount of rupees 5,000 each to both the first petitioner and the second petitioner. Accordingly, the appeal is partly allowed.
Cell number 20. Srinivasan for petitioner. Halim Amin for respondent.
Interim order is an amount of 9,000 per month.
Not complied with? Complied with interim order?
No, my lord. Only still 1,50,000 plus is pending.
Yes.
My lords, he has been, I'm instructed to submit, my lord, he owns a medical shop in a rural area in a Janta colony, and his earning is about 10,000 rupees per month. He, in all, my lord, he earns, according to his case, 20 to 30,000 rupees is the total turnover, wherein he gets about 20% of it, 20% of the thing as his profit. And he has been paying about, as and when he is paying about 3,000, the order sheet reflects when at 3,000, 4,000, other, in that.
3,000, 4,000.
Everybody.
Yes.
He is paying as and when it is possible for him to pay. Milad, I am instructed to submit Milad. Now, Milad, he is liable to pay about 2,81,000 rupees as on this month. Milad, in all, Milad, according to him, he has paid about 1,69,500 rupees so far. And Milad, he is still liable to pay 1,19,500 rupees, subject to what my learned friend
You
would
have
say.
an interim order. On
No,
the
madam.
Conditional interim order.
Interim order
is
illa,
there.
Satya. Illa, interim order illa.
Interim order alla?
I don't think I have.
If interim
Well,
order
last
is
time
not
I
there,
had
then it's open for you
Final
to.
order.
final order.
Final order, my lord, 9,000.
Before this court, I'm asking.
No,
you,
madam.
If
No.
there is no interim
No,
order,
I was.
you could have executed it. You could have executed it. Less is matter.
And
After 1 month.
the 498 case filed also, he got.
Yes,
stayed, my
is
lord.
you have your remedies. Next.
Cell number 21.
Let him pay about 50% of it, minute. I will direct him to pay.
He has buildings with the.
Next, 21.
Cell number 21.
Yes.
But subject to certain payment of the amount, minute, let the order of the court be stayed.
No, like 50% of the amount, all the arrears.
Minute, Lordship may kindly dictate, minute. I will ask him to deposit.
I'll file objections in that case. She has no any means, he has buildings.
You don't, your client requires money, isn't it? You are going to get it. It is not that court is going to go pass a final order.
As your lordship suggested, I will execute also.
Then do it. Yes, 21.
Cell number 21.
Minute. Let him be directed.
What was he doing from 24 without an interim order? So it is not required in 25. Yes, 21.
21. PM Adas Swami for petitioner.
Yes, what is the husband's petition?
Husband's petition.
How much is awarded by the court?
Awarded, my lord, 3,000 to the daughter, my lord, and 5,000 to the wife, my lord.
8,000.
What happened, my lord? This earlier in MC petition, which was filed by the husband, my lord. Already there is an order at page 67, my lord, which has been ordered to be paid to wife, my lord. 3,000.
How much?
3,000, my lord.
Uh,
Now, my lord, what happens is he's working in a mobile shop, my lord. Wife also admits, my lord, in a statement of objection.
How much is earning?
This in according to his affidavit of assets, my lord, 8,000 he has mentioned, my lord. It's a small menial job what he was doing, what he is doing, my lord. 8,000 it's ordered, my lord. Now because it has not been advertised, it has not been considered in this petition also, my lord. Petition filed by the wife for maintenance, my lord. Whereas
3,000 to the wife or 3,000 to children, to the child?
3,000 to the child and the wife, 5,000 to the wife, my lord.
So now we will deduct that 3,000 from this 5,000. So till 2,000 is left to the wife. And for 3,000 to the children, that it comes to 5,000.
That's condition.
Land counsel for the petitioner submits that in other case, the wife is already granted an amount of rupees 2,000 and the same was not 3,000 and the same was not brought to the notice of the court and the court had granted 5,000 as maintenance to the wife. And his income is only 8,000. Considering the submission of the land counsel, there shall be stay of all further proceedings, saying 5,000, 2,000 to the wife and 3,000 to the child. Arrears also 8 weeks. Yes. Next.
Notice.
Notice to the respondent.
Cell number 22.
Hearing for the petitioner in this case, my lords. Petition is filed by the minor's son, my lords. Respondent is the father of the child. The order passed by the trial court, my lords.
You're seeking enhancement.
No, my lords.
Your
The
petition is dismissed.
petitioner was dismissed, my lord.
Notice.
Cell number 23, still hearing B group. Gautam Raghunath for petitioner. SK Pratima.
Before the petition.
There was an order passed,
Senior
it's an
counsel is on
interim
VC.
visitation will be continued as before. That is when I had to do the memo to see clarification that there was no interim arrangement. It was only because of the settlement talks, my lords. I think your lordship is well aware that went on for about 1 year. Otherwise, there was no interim
No,
visitation.
in that case, it has to be, no, on that visitation itself, the matter has come before the High Court, isn't it?
My lords, 30% what was awarded.
That
Yes.
was questioned.
From
with the
morning
file.
to evening.
Please come to the impugned order. Where is the
Yes,
impugned
my
order?
lord. 7182, their petition itself.
Page number.
My lords. Plus it's at 40. $54 minutes. May I read the relevant portion? 52, I'm sorry, my lords, 52 it is. Which says 30%. 54 is the end page. IN number 11 and filed under section 12 of so and so so and so on behalf of petitioner is allowed in part. Petitioner father is entitled for the visitation, parenting right of his minor son, master so and so. 30% during all summer vacation, Dasara vacation and Christmas vacation from 11 a.m. to 5 p.m. either in the petitioner's house or any place comfortable to both the parties to be chosen by both the parties. This is what it says. Against that, both the parties have filed, in fact, writ petitions.
No, this
One by
IA itself is filed for what?
Well, to
Sir,
enhance. They have sought enhancement.
No, how they wanted it. Come
Look,
to
they
the
want
starting of the order.
50% is what they are asking.
Application so and so,
I'll
and they
come to
have
the
to
relevant
grant
IA.
50% during all summer vacations, Dasara vacation, Christmas vacations, birthday, minor son's birthday, and all festivals in the interest of justice.
Because earlier there was a joint memo filed by both the parties in GNWC where an arrangement was arrived till the disposal of the GNWC petitions that are filed by both the parties. It was the day visitation also.
Yes.
That joint memo, my lords, your lordship will find it at 162.
So then it doesn't deal with the weekly ones. There is no order.
It's weekly ones. That is the joint memo I'm talking about.
Okay.
Joint memo is
Your Lordship, this was a joint memo that was filed much prior to all the other violations that were done, and even the joint memo was violated. Your Lordship, we are ready to argue the matter in the main itself, Your Lordship. Might I
162 is
request,
the joint memo.
just 1 minute. Might I request Your Lordship, if Your Lordship could take it up tomorrow? Reason, I apologize, I'm not before Your Lordship, since there are 2 other tribunal matters also. Therefore, I was trying to parallelly manage. Your Lordship, if Your Lordship's to hear this
We'll
matter,
have this matter on Tuesday.
Tuesday.
Tuesday, Your Lordship,
Next
please.
Tuesday. Next Tuesday.
This is
Please,
matter.
please, grateful.
7.
Yes, next.
Cell number 24.
Plus, let there be, just in case, let there be clarification that the interim visitation, what was passed last time, to continue, let it not.
We'll hear it on that.
We'll hear
We'll hear it on Tuesday. Yes.
We are per petitioner, my lord.
24. Manjunath V. Rayappa.
Morning, I have received the memo of calculation, my lord. I will verify and submit next week, kindly one date, my lord.
This
For
is
the
matter
responding
on
mistake.
next
Filing
day.
the objection and memo for calculation.
The objections are taken on record. This is matter on next Thursday.
Please, my lord.
7.
Yes,
Yes.
verify.
Cell number 25. Sachin BS. Sachin BS for petitioner.
I appear for the petitioner.
Kalni.
Lord, senior is in quote all 3, my lords, and also, my lords, the client has, my lords, instructed us, my lords, to engage the senior counsel. So I require, my lords, a week's time.
I oppose for this reason. The very same documents were sought to be produced earlier. They were rejected by a considered order relying on my lord's judgment. And against the same, he says for files, well, I'm not referring to my document, his document. The same documents are produced and the court says, I cannot burden my record. They have been already rejected, confirmed by the High Court, I will not interfere. And obtained an order of stay saying that it's at the stage of evidence, it's a stage of argument. Well, there's a limit to tell lies.
That's my petition.
Now, this is another lie. Well, an advocate on record can
I've
argue.
already heard this matter, my lords, in the last occasion when my lords were sitting as an in-charge court hall, my lords also. Lords, this.
When was the stay granted? Who granted stay?
Lords, the coordinate bench, my lords, have granted the interim order of stern 25 to 25.
By suppressing the truth.
There
By
is nothing,
your
my
lordship
lords,
had
there is
declined.
no suppression of truth, my lords, there is nothing.
No, your lordship had
This
declined the order.
Wrong, my lords, by the senior counsel.
No, no, I'm supported by record. Your lordship declined to grant the order when it came before another judge when during the absence of my lord. And then interim order is obtained and against in our absence. And I'm pointing out this, will kindly turn to the statement of objection filed by him, this compilation.
But the application that is filed, my lords, previously was for interim maintenance. That my lords have confirmed it, my lords, after hearing. Lords, this application is, my lords, for summoning of documents of the bank records, my lords, of the husband. Lords, where the bank accounts are, my lords, with the joint with mother and father. My lords, as my lords have held against me, against my client, my lords, in a previous case, my lords, where my lords have held that merely because the account is with the joint with the mother cannot be a ground for rejection of summoning of documents. That is exactly, my lords, the precise question that is arisen, my lords, in this writ petition also. Lords, there is no suppression of fact, there is no suppression of material. My lords, the submission, my lords, is absolutely wrong. Lord, that is why, my lords.
What is the impugned order? Let's see the impugned order.
Rejection
Lords,
of
annexure A.
Page number.
Lords, 24, my lords, is the order. 25, my lords, is order on IA. Lords, 28, IA numbers 16 and 17. Lords, also to bring my lord's attention to my lords, my lord, I have also filed IA number 7 previously under the same provision, which was rejected, saying that it is premature. Now, my lords, I filed it after my evidence.
No, we'll read this order at page number 6.
Please. Lords, page number
28.
28. Orders on IA 17 and 18. 16 and 17. The respondent wife has filed IA number 16 and 17 under order 16 rule 1 and 6 read with section 115 of the CPC respectively to summon documents from the witness / bank managers number 1 to 7 and witness bank managers 1 to 9 respectively. The petitioner husband has filed separate objections to both applications. Heard so and so, peruse the contents of application affidavit objections. The respondent in IA number 16 and 17 has sought for an order to summon the bank / bank statements of the petitioner. His parents maintained in Union of Bank, Falnir branch, Karnataka Bank, so and so, so and so, so and so. The applicant / respondent in the affidavit filed in support of the application has stated that the petitioner has separate facts of various accounts held by him since year 2018. The accounts of the statement produced by the petitioner before the court relating to his account maintained in HDFC Bank, Kankanadi branch is incomplete. He is holding individual and joint account with the mother and also as a founder, director and chief executive officer of the CHT group, EPHC so and so, so and so, so and so. The petitioner alleged to have diverted lakhs and crores of rupees from his individual account from account of his parents, and they are signatories to those accounts. Hence, he has paid for an order to summon the witness and documents from the bank. The petitioner in objection stated that the accounts referred to in the application does not belong to him. The documents are sought relating to the person who are not parties to the litigation. The CHL group bank accounts FCRA maintained by the Home Ministry and other institutional accounts which are not party to the proceedings. Therefore, he paid for dismissal of the application. The petitioner husband has filed so and so decree under section 10(1) of the Divorce Act seeking dissolution of marriage by decree of divorce and other reliefs. The respondent wife has filed a counter seeking monthly maintenance, litigation expense and permanent alimony. In this proceeding, the petitioner was examined as PW1 on 7/9/23 and this affidavit runs to total 37 pages. He has been cross-examined on behalf of the respondent from so and so, so and so, so and so. And
so and so,
from 26 hearing
dates.
26/9/23 to 6/11/24 on 15 hearing dates. And the cross-examination of the witness runs to total 110 pages. The respondent has filed affidavit containing 59 pages in lieu of her examination in chief, and she has produced in all exhibit R1 to R63 documents. The witness was cross-examined on behalf of the petitioner on 10 hearing dates, and her cross-examination runs to 88 pages. This Honorable High Court has issued a direction in writ petition so-and-so to conclude the trial of the present case and dispose the petition at earliest. The respondent, having availed all opportunity to cross-examine at length and in full regarding sources of income of the petitioner and details of his bank account statements, in the event the petitioner suppressed his income and failed to produce the required documents, the respondent can seek to draw an adverse inference against the petitioner. As the descriptions furnished by the respondent in both the applications, the name are jointly appearing in the name of the petitioner and his parents, Mr. Edward Paul Fernandez and Cynthia Irene Fernandez. Among them, few accounts are exclusively appearing in the name of the parents of the petitioner. They are third party to the proceeding and stranger and to the matter in dispute. The respondent has failed to make out any case to summon their bank account statements. The respondent in this proceeding already once had filed similar application IA number 7 under section 151 of CPC to call for documents of the petitioner. The said application came to be dismissed as per order dated. So,
how are you agreed with this order?
Please, my lords.
How are you agreed?
My lords may see my IA, my lords, that I filed. My lords, IA number 16 and 17. 16 and 17. My lords may see page number 310, my lords.
If a family court gets at least 10 cases of this nature in a year,
please,
that is sufficient. They will not, I think separate family courts have to be constituted.
Lords, I understand, my lords. This case, my lords, only on the ground that there is a earlier disposal or dismissal of the writ petition. Lords, there is no ground, my lords, or reason.
So there is an order for early disposal.
Please, at the earliest.
Here and you take every time stay.
My lords, that is why, my lords, IA number 7, my lords, was dismissed on the ground that it is premature.
Where is that? Where is that? You say I 320?
310, my lords. Page number 310, annexure L1. Lords, these are the witnesses, my lords, sought to be summoned and documents to be produced. Lords, in the first, the manager, Union Bank of India,
There is the earlier order passed by this court.
My lords, the earlier order, my lords, is under interim maintenance and not under
Whatever
this.
it is.
Please.
What is the order passed by the court on this particular aspect?
On this particular aspect, nothing has been
With
touched.
regard to the bank account and all.
Nothing, my lords. Only on the ground that the wife is sufficiently, lords, she can maintain. It has dismissed my application for interim maintenance. My lords have only dismissed it. On the ground that she has sufficiently the education qualification to maintain herself, and she is only obliged to get.
No, with regard to calling for the bank manager, the accounts, where is that?
Nothing, my lords. There is no application. We have not challenged that, my lords. IA number 7 was dismissed. That we did not challenge because there was a finding that it is premature at the time of evidence of the petitioner. We did not challenge it, my lords. Now we have challenged. We have filed an application again under order 816 rule 1 and 2 for summoning of documents at the time of respondent evidence. Lords, it is dismissed.
Yes, Mr.
Yeah, ma'am, kindly turn to page 310.
Yes.
The summoning is of order 16, rules 1 and 2, 1 and 6. There are 13 documents ought to be summoned here. They will end up with page 300.
Lords, that is important, my lords, to show
300,
that
316.
whose account and in whose name it is. My lords, every PAN card.
In IA7. The lieutenant judge would refer to it, saying that the same I have rejected. Kindly turn to the next page. My lord was engaged with that page 30. I request my lord's kind attention to page 31. Unnumbered para. Respondent in this proceeding already once filed an application, similar application, IA 6 and 7, 151, to call for documents from the petitioner. The said application came to dismiss as
So according to them, it is dismissed as premature.
My lords, may see page number 301.
The question is whether they have necessary and
So
material.
let's see 4/4/2024 order where it is.
Lords, 4/4/24 order, my lords, is
I
lords,
think
that is page number 294, annexure K.
294.
294. That, my lords, the reason at page number 301. 294 is the, my lords, 4424 order under IA number 7.
Where is operative position?
My lords, the page number 301, my lords, is the opinion, my lords, that is given by the court. Para 12. In my opinion, the present application is premature. In other words, if the said statement of the bank accounts and other accounts pertaining to the petitioner are relevant, then the same can be summoned when at the time of evidence of the respondent commences. That too after securing the detail of the addresses of the bank said institution. Moreover, based on the information available in the TIS of the petitioner, the counsel for respondent can effectively cross-examine and elicit the information from mouth of the petitioner about those accounts and particulars. Lords, my examination was
For the 13 also read.
Please,
Yeah,
Lord.
13.
If the petitioner does not wish to produce those documents in the case or during his cross-examination fails to disclose the details or information of the same, then an adverse inference can be drawn against him. In my opinion, the present application is devoid of merits and the same deserves to be rejected. Hence, I have answered the point considering accordingly. Lords, at one instance, my lords, they say it is premature because they have not given addresses of the bank or bank statements.
No.
Now, my lords, they reject on the saying that it is not relevant.
Yes.
Premature is an incidental reason given, but the ultimate reason given for dismissal is para 13. Para 13 can be confronted to the witness, or you can produce it at your stage. Her evidence was over. Case was posted for argument. The case was posted for argument, and then we were asked to file written submissions. We have filed written submissions. Then on the day when this it was set down for either posting it for judgment, he files this application.
But unfortunately, this paragraph number 12 and 13 are not going together.
Please.
Maybe whatever, either they say dismissed or allowed, whatever they have said, but the reasoning 12 is something, an option is given to them to raise this issue again.
I have understood that they did not do it. That's why if
my lords, that is
I missed that point. I missed the narration. But opportunity was given to the respondent or to the wife. I would use the word, your lordship have used the word wife throughout. Wife with an opportunity was given to her to produce these documents or confront it to the other man, husband. That is not done. Number one. Number two is when she filed his application and they were rejected, she would not take it up further. Now, on the ground that is premature. No, it's not premature. It was appropriate. Then the cases are both sides, evidence is over, and case is posted for arguments. If necessary, I will show the order sheet.
27-125, the argument, the evidence of the respondent evidence was closed.
I'm showing the order sheet.
When is the order for disposal by this court?
Lords, lords, as per their contention, lords, that lords, notice was not issued in that, my lords. It was disposed.
No, notice in those cases, the court is not.
Lords, in 5-4, in WP 5424, 5424 of 24. Lords, the.
Dated?
I'll give you the order.
Take that order.
Kindly, madam. Kindly take the order. And the second order also you can give.
This is 11th March. No, please come from 11th March 2024. What has happened?
I don't have a lords.
Proceeding sheet.
Order sheet runs into 800 pages.
800 pages.
And another thing which I should inform your lordship is she has filed income tax returns in the court below and there are copies of the income tax returns. She declares her status as not married up to 2023.
That is all.
1 minute. Up to 2023. In 2023, she says, I'm married.
This court on 11th March has directed the trial court to dispose of the matter. 1 minute. To dispose of the matter as expeditiously as possible, but not.
Beyond 30, your lordship has said.
As expeditiously as possible. The petitioner shall place before this court the proceedings of the court right from the day of the order passed by this court till today. List this matter on Monday.
Please.
That day, whatever you want to do. Senior or-
The income tax returns will show. She declares the status as.
Lords, that is, my lords have already dealt with that, my lords. We will not go into that.
We will decide.
I'll give it to your lordship.
We'll deal with it on that day. Please, Monday.
Pass over matter.
Lords, interim order, my lords, to be
Extreme order granted is extended till then.
Pass over matter, serial number 4, Naveen JN. For
I
petitioner.
appear for the your lordship in this case.
Yes, Mr. Naveen.
I
What is wrong
apologize.
with the order of the
Yesterday-
court? No, it's okay.
Lordship,
What is wrong with the order of the court?
Lordship, may I make one request to your lordship? Lordship, I got some inconvenience today. I will come and physically argue your lordship before you, lordship.
Tomorrow.
Next week.
My lord,
Tomorrow.
my lord, the MFA 53365 of 23 can be clubbed to in this.
So that,
The
we
same,
will see.
MFA
same.
is for the
No, no, no. For passing orders in this, that is not required. We can pass independently. Even right now, I can pass orders. Anyway, is asking time tomorrow.
Yes, ma'am.
Tomorrow,
Please.
this is matter tomorrow. Signatures.
Synoptic note.
Synopsis and all taken on record. Yes. Whatever, no? Tell her what is it. No signatures. Same.
Synopsis and notes taken on. Yeah, that's fine. Last file. Filed in court के below. Statement. That order. PD trial order. It already filed. The synopsis and notes filed in court below. ಅದು ಯಾವ್ದು 4500 ಫೈಲ್ ಹೋಗಿಲ್ಲ ಇವತ್ತೊಂದ ನೆನ್ನೆ ಅಂಜಲಿ ಒಂದ್ ನಿಮಿಷ ಇದು ಇವತ್ತೊಂದೇ ಅನ್ಸುತ್ತೆ ನಿನ್ನೆ ಅವ್ರು ಬಂದಿದ್ರಾ 4500 ಎಲ್ಲಿದೆ ಅದೇ ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಎಲ್ಲ ಅದರಲ್ಲೇ ಇರುತ್ತೆ ಏನ್ ಬೇಕೇಳಿ ಹಾ ಅದೇ ಸಿನಾಪ್ಸಿಸ್ ಅಂಡ್ ನೋಟ್ಸ್ ಜೊತೆ ಪಿನ್ ಮಾಡ್ತಾರಂತೆ ಕೊಡಿ ಅದು ಎಲ್ಲ ಫೈಲ್ಸ್ ಏನು ಮಿಕ್ಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಲ್ಲೇ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ ಸುಮ್ಮನೆ